The Appellate Division, First Department, is now in session. Good morning and welcome to the Appellate Division, First Department's virtual oral argument. I will now call the calendar. People versus Harley. Is the appellant present?
Yes, Alexandra Mitter for Appellant Hashim Harley.
Okay, so you have 6 + 1 for response. Is the respondent present?
Yes, Your Honor. Jennifer Watson for the people.
5 minutes. Paulino versus Chen, submitted. Matter of H children, submitted. Ruiz versus Selzer, submitted. People versus Garcia, submitted. Lembo versus Rosiana. Is the appellant present?
Yes, Your Honor. Jennifer.
Go
yes,
ahead.
Your Honor. Jennifer McDougall for the appellant, Robert Rosania.
So you have 8 minutes + 2 for response. Is the respondent present?
Yes, Your Honor. Jeffrey Berkowitz for Matthew Lembo.
7 minutes.
Thank you, Your Honor.
People versus Ramirez, submitted. Huberto versus Subcup, submitted. Leffler versus Kotick. Is the appellant present?
Present. Joel Kotick for the appellant.
5 minutes. Respondent. Okay, the respondent had asked for oral argument. People versus Ford. Is the appellant present?
Yes, Anastasia Heeger for the appellant.
6 and 2. Is the respondent present?
Yes, Your Honor. ADA Nicole Nichols for the people.
8 minutes. Riverkeeper versus Port Authority, submitted. Val versus the Port Authority. Is the appellant Port Authority, represented, I believe, by Christopher Simone, present?
Your Honor, it's Jonathan Schaub for the appellant's Port Authority and Turner Construction.
You have 5 and 2.
Thank you, Your Honor.
As the defendant's, the appellant's city.
City Lumber is present, Your Honor. Glenn Kaminska, Amity Demers McManus.
Okay, you have 5 minutes. And plaintiff?
Yes, Your Honor. Scott Singer.
6 minutes. People versus Silvestri, submitted. Brown versus New York City Department of Transportation, submitted. White versus MP40 Realty, submitted. Petrishko versus Animal Medical Center. Is the appellant present?
Yes, good morning, Your Honor. This is Ian Wallace for the appellant. 5
minutes. Is the respondent present? Respondent?
Yes, Your Honor. Lou DiLorenzo from Bonshenick and King on behalf of the Animal Medical Center.
5 minutes. 80 Broad versus BSD 80, submitted. Green versus State of New York. Is the appellant present?
Yes, Your Honor. John Schutte for the appellant.
5 minutes. Is the respondent present?
Good morning, Your Honor. Linda Fang for the state.
4 minutes. Patch versus Bobolin. Is the appellant present?
Yes, good morning, Your Honor. Stanley Schlein for the appellant.
You have 10 minutes. Is the respondent present?
Yes, good morning, Your Honor. Brian Mangan for respondent.
So you have 5 minutes. We're going to take this case out of turn. Patch versus Bobolin is going to be the first argued case because Justice Manzanet has recused herself. Justice Eng, who I believe is present on the Teams feed, has been vouched in. So, Patch versus Bobolin, the appellant may proceed.
Thank you, Your Honor. Good morning, Your Honors. We appreciate the opportunity to make our presentation today. This court is most familiar with the Article 3, Section 7 of the New York State Constitutional provisions requiring a 5-year uninterrupted electoral residency in the state of New York for any candidate for the public office of either state senate or assembly for the New York State Legislature. This court most recently ruled on a fact pattern involving this constitutional provision as late as 5 months ago. And we are here with another case in that domain. Your Honor, let us be clear. The period that we are arguing before this court that is relevant is the period from November 15, the month of November 2015, through and including, of course, this coming November 2020. But very specifically, the issue before this court involves the period from November of 2015 through and including mid-March of 2016. That 5-month period, 4.5-month period is what is at contest here. And let's make no mistake, Your Honors, the provisions of this Constitution requires
This is Judge Friedman. Your position, if I could summarize it in a nutshell, is that for the pertinent period, the respondent was resident in Illinois. There's a lot of documentary evidence which supports that. There's no documentary evidence indicating during that period a New York residence, except the evidence that the respondent presents is the expression of an intent to return to New York. Isn't that basically your case?
That is, in fact, an accurate summary, Your Honor. But I'd like to remark about that intent issue very specifically, because there is a smoking gun here. The intent to return can be visualized with Mr. Bobolin when he attended Bard College. Instead of returning to New York, staying in New York State, he intended to return to the state of Illinois. He declared, in fact, a return to that particular Superior Street address in the state of Illinois right after attending Bard College. This is the inverse of Kaufman, which this court recently ruled on. And the indicia that we are pointing to very specifically.
Well, in Kaufman, there was a residence maintained in New York throughout. I mean, he always used a New York address, and he always had a New York license. Unlike the case here, where there was a Illinois license and there wasn't a New York address.
Agreed, Your Honor. Absolutely agreed. And in fact, the first physical indicia of a New York residence for this candidate occurred in the latter part of the month of March of 2016, well within.
This is Justice Moulton. How do you grapple with his allegation of having residence in Albany with his aunt?
I'm sorry, Your Honor is broken up.
Oh, I'm sorry.
No, I can, yes.
I'm talking about the alleged residence in Albany. How do you grapple with that?
Certainly, Your Honor. I'd be glad to. From the age of 13 years old in 1996, through and including the year 2016, which I've referred to, the entirety of Mr. Bobolin's physical residence in the state of New York at that Ramos Street address was for a period of an aggregate of 10 months. 10 months. And we consider that to be he visited. There was no residence there. It was a visitation at that location. And in fact, his aunt, in the transcript, said that, in fact, he visited me. He didn't live there. So, Your Honor, having a New York state of mind, like Billy Joel says, does not convert into the requirements of the New York state of law. I'm sorry.
This is Judge Kern.
Thank you, Your Honor.
How should we deal with the fact that the judge below held hearings, took testimony, and made various credibility determinations based on that evidence, and wrote a very well-reasoned decision finding that his intent was always to be in New York?
Obviously, Your Honor, we take great exception to the decision below. We appreciate the fact that the hearing judge is the trier of fact in the initial phase, but in all candor, she erred in disregarding all the physical documentation and the physical evidence that we presented. Her reliance on teach out and saying that, in fact, the evidence did nothing more but present ambiguities in the residency calculus is just completely erroneous, Your Honor. There was no physical evidence of anything other than his intent to, in his mind, to have a New York state of mind and his family living in New York for generations. That doesn't create compliance with the Constitution.
This is Judge Owing. I have a question, and there's something in your brief at the end of the conclusion that struck me. The respondent here has an alleged Albany address, correct?
Yes, Your Honor.
But yet he's running in the assembly district for the 75th Assembly District, which is down here, correct?
Correct, Your Honor.
Well, I thought it struck me that you were telling me, you were making the argument about how, how can this be that he's got no connection at all? If anything, there may be a connection in Albany, but where's the connection here in the 75th Assembly District, correct?
There is none, Your Honor. Precisely the point. If we now focus on the judicial interpretations of the residency requirement, particularly that of intent to return, there was no intent to return to Ramos Street. There was never an intent to return to Albany. His waxing poetic throughout the documentation he presented, whether they be emails or newspaper articles or interviews, always intended to move to New York City. So, Your Honor, we concur with that confrontation you have just posed to us.
Do any of my colleagues have any further questions?
One other question I have, this is Judge Owing. Counsel, there's also in the record that he not only had one job in Illinois, he had two.
Correct.
So
Correct,
that
Your Honor.
was, it was very different from the other cases where they only had one job and they decided or there was an intent to come back to New York. This individual here had two jobs. He left one job and took another job in Illinois, correct?
That is absolutely accurate, Your Honor.
Always paid Illinois state taxes, never paid any New York City residence tax.
That is correct. And by the way, when he filed his federal tax returns, he always subscribed and declared the address from which he is paying from the Illinois address. That's in the record.
There were a couple of emails which, of course, predate the periods we're talking about in which he expressed an intent to come back to New York. How do you deal with that?
In the balance of facts and indicia of residence, self-serving emails don't override the multitude of physical actions taken by this candidate. Driver's license, tax returns, voter registration and voter activity, jury duty in the outlier state. None of these override by a simple email or an interview.
When Kaufman, the candidate, did jury service in Manhattan.
Correct. And so did this candidate in 2019. I'm being snarky, Your Honor.
Not in the period that... Not
correct. Correct, Your Honor.
Do any of my colleagues have any further questions? Thank you.
Thank you, Your Honor.
The respondent may proceed.
Good morning, Your Honors. Brian Mangan for candidate respondent. May it please the court. Before I get into my opening statement, I would just like to point out that appellant's argument, I think it should be very clear to members of the bench and bar, their argument is based entirely not on the notion of domicile as we know it in New York or under the election law, but rather premised on the notion of residency. And there's no question about the fact that Mr. Boblin was for a time.
Can you have what? This is Judge Friedman. Can you have more than one election residence?
You cannot, Your Honor, under Glickman, which says that you may have multiple domiciles, but you may decide,
only one election residence.
You may choose which one of your residences to which you have a legitimate, significant, and continuing attachment. And, Your Honor, to say it's very, very clear under this precedent. And
let me interrupt you. This is Judge Friedman. Basically, what your case comes down to is the respondent saying, look, I always intended to come back to New York. And this intention, which is obviously subjective, that I intended to come back to New York satisfies the constitutional and statutory requirements.
Well, Your Honor, what the appellant seems to do here is they seem to say everything that happened before 2015 was irrelevant, but then also at the same time argue, well, if you look at this period between when he was 13 and 30, he was never here. So I think appellant really needs to pick a lane. Which one is it? Is it the 5-year period that we're talking about here, or is it his life? Because, Your Honor, the court below correctly held that Patrick Boblin is a New Yorker. He was born and raised here. That's in the record. He's lived the majority of his life here. And the fact finder
So I thought he lived the part of time in Massachusetts.
That's correct, Your Honor. So he was born and raised in New York. He went to Massachusetts just before college.
Age? Yeah, okay.
At the age of 13. When his parents split up, he went with his mother to Massachusetts. When he was in college, she came down with cancer, unfortunately, and she returned to the state of New York. And then as soon as he graduated, from college in Massachusetts, he returned to New York to live with her, where she was living with the grandparents. And one other point of fact, Your Honor, is that I believe it was Justice Moulton who made reference to the Albany residence where he lived with his aunt. But in fact, his father has been living at the Ramo Street residence in Albany for about 15 years, along with his aunt, and that constitutes the majority, the entirety of Mr. Bobelin's close family. So it's not simply just some house with his aunt in it.
How many months, I mean, counsel said that if you calculate all the time he spent here in New York, it's 10 months. So it's leaving away from the from the time he was born to 13 years old when he moved to Massachusetts.
Yeah, that's right, Your Honor. If you exclude all the time that he was in New York in his life, he was never here.
13 years he was here.
He was here from his entire. I'm sorry.
You have to stop saying entire life. For 13 years, from the time he was born to 13 years old, he was here unquestionably. But then he moved to Massachusetts. When he moved to Massachusetts, is counsel correct? If you calculate all the time that he came back, it was 10 months.
In between the period when he returned to New York after college in 2009, and then when he returned to New York again in 2016, if you look just at that period of time.
Just do the math. I can't do the math. Do the math for me. Is it 10 months or more than 10 months?
Well, he lived at the Ramo Street residence for 6 months consistently in 2009.
I'm answering the question. It's a very simple question. It's either yes, it's 10 months, or no, it's not 10 months. But okay, I got the answer. Thank you.
Thank you, Your Honor. Now, if we were to take his life as in its totality, which is what I think appellant wants to do sometimes, he has lived the majority of his life here, including the last several years, consistently within the 76th Assembly District. Now, Justice Edmead came to these conclusions after a full evidentiary hearing, 3 witnesses, 24 exhibits, and a full written marshaling of the evidence. And she found not only did the appellant fail to meet.
I'm sorry, counsel, you say he lived in the 76th Assembly District? I must have missed that in the record. Where did he live in the 76th Assembly District?
The petitioner, the candidate, when he was in Chicago and clearly expressing his intent to return, which was actually quite remarkable because not only did he say he intended to return, but he actually has an interview in a magazine in early 2015 where he's interviewed about how he's going back home to New York, Your Honor. He actually came to New York in 2015 twice, once specifically to look for apartments in New York City, and then returned in early 2016 in body. So he's actually been within the district.
Oh, no, but that's very different when you said that he lives in the district. Does he have an apartment? Because my recollection of the record is that he's relying on the Albany address, and unless I've totally missed it, I didn't see a New York City or Assembly 76th District address.
Your Honor, I'm incredibly glad you're giving me the opportunity to clarify this because Patrick Boebelin has been living in the 76th Assembly District since February 2016. So he's been here for 57 of 60 months in the Assembly District exactly. So this is not just saying he had this Albany.
What's the address? Where's the address in the record? I must have missed it there.
Yeah, he moved back to 1586 York Avenue in February 2016.
2016.
So, you know, appellant wants to talk a lot about the intention of the law, and it's clear that the intention of the law.
But of course, 2016. We're measuring this from November 2015, right?
Yes, that's correct.
You had to be back in New York in November of 2015.
Right.
Yes.
I'm sorry.
Do any of my colleagues have any further questions?
Sure.
Okay. Thank you both.
Thank you, Your Honor.
Thank you. Thank you, Your Honors.
Justice Freeman, I'm going to be signing off.
Yes, and I just want to be sure that we have Judge Manzanet back with us.
Okay, thank you.
Judge Manzanet. Is Judge Manzanet back?
I'm here.
Okay. I think we were having a temporary technical problem. Okay, so People versus Harley, the appellant may proceed.
Good morning, Your Honors, and may it please the court, Alexandra Mitter for Appellant Hashim Harley. Before I begin, I'd like to reserve my right pursuant to Rule 1250.1b to re-argue in the event that another judge needs to consider this case. Now, Nadira Moses' testimony constitutes newly discovered evidence under Salemi. The court just got the law wrong. Evidence that is newly available is newly discovered within the meaning of CPL 440.10.1g. Decisions involving co-defendants asserting their Fifth Amendment rights make that clear. And there's good public policy.
This is Judge Kern. How can it be newly discovered evidence when the defense counsel acknowledged that he met with Moses shortly after the defendant was arrested? So he had that information right after the arrest. Based on that, how can it be newly discovered?
Because it was not available to the defense at trial. And the law is clear that where evidence is unavailable, it fits within the newly discovered evidence requirement. And there's a good public policy reason for not drawing such a distinction there, because a defendant who knows about exculpatory evidence but is powerless to offer it at trial shouldn't be differently situated than that same defendant who learns about the exculpatory evidence later. The only two decisions that respondent cites to the contrary are completely distinguishable because in that case, in both of those cases, the evidence was in fact available. In Taylor, which was the only case that the lower court relied on, the newly discovered quote unquote evidence was the fact that the co-defendants didn't know each other. But that doesn't implicate the Fifth Amendment. Either of the co-defendants could have testified to the fact that they didn't know each other at trial. And so this court explicitly distinguished the cases where the co-defendant would have had to say something inculpatory, because in those situations, it is not practically available to the defendant. Now, respondents suggest that we could have offered Ms. Moses's prior statements, quote unquote, but there are no prior statements. Police didn't bother to interview her, and the prosecutor didn't bother to call her as a grand jury witness. And I don't know of any exception to the hearsay rule, and certainly respondent doesn't cite any exception that would allow a defense attorney to get up and recount on the record his conversations with a witness from several years earlier.
Counsel, this is Justice Moulton. Would you address the probability of a different result if she had been allowed to, or if this evidence had been introduced, given that the victim knew Mr. Harley and had a nickname for him? Mr. Harley had been in the victim's apartment. I know it's an ID case and there's the ID of the victim is crucial, but it seems like that's sort of locked in. So can you address that there's no probability of a different result if this evidence had been introduced?
Absolutely. So just to be clear, the standard is that it probably would have led to a different result as opposed to the inverse of that. But the point here is that there was absolutely no evidence corroborating the complainant's identification. There was no video, no DNA, no fingerprints, no second assailant, no missing property connected to Mr. Harley. And so, yes, they knew each other. But Ms. Moses's testimony about a lookalike perpetrator would have given the jury a reason to find that the complainant was mistaken about his identification without finding that he was lying about it.
Let me ask you about a different. The defendant's sister testified at trial, didn't she? That the defendant arrived home at 1 a.m. But didn't the defendant tell the police, according to the voluntary disclosure form, that he was home or had arrived home at 9 o'clock?
So there's a few points in response to that, Your Honor. I think the idea that a person with the significant cognitive difficulties that Mr. Harley has could specifically remember the times that he didn't do something that happened 2 weeks earlier on a day that was, as far as he was aware, a completely unremarkable day is just really, I think it's reading too much into that voluntary disclosure statement. And if you look at the statements that he actually made, the written statements, they're reflective of someone who has sort of no idea what is going on. They're really all over the place.
Judge Kern, going back to the issue of a possibly different result, what relevance is it that Moses was not an eyewitness to the incident? So we have an ID from the complainant, which is a very strong ID, and she didn't witness the incident. So how would that have created a different result?
Absolutely. There's simply no way that the people she saw were not the actual assailants, because she came in and saw the complainant on the ground floor, and he spent at most 2-3 minutes on the ground floor after being attacked. The testimony that is clearly established in the record as far as the chronology goes, based on the time of the 911 call, reporting the assault in progress, and the time that EMS arrived, only 5 minutes later, to find the complainant in his apartment. So the likelihood that Ms. Moses walked into her apartment after the attack, in the 2 to 3 minutes after the attack, and saw two people who she recognized as not living in the building, and it's a small building. She knew they didn't live in the building. They perfectly matched the complainant's description of his attackers, and they were worked up and angry. So the idea that she saw someone just coincidentally other than the two people who actually perpetrated the crime is simply not credible. And I think the point here is that all we're asking for is a hearing. It's not a super high bar to get a hearing. And I really encourage your honors to go back and look at CPL 44030 subsection 4, because I did it this morning, and just none of those subsections, and it's narrowly circumscribed rules that allow a judge to deny a 440 motion on the papers, and just none of them are applicable here.
Do any of my colleagues have any further questions? Thank you. You have time in response.
Thank you.
Respondent.
Good morning, Your Honors, and may it please the court, Jennifer Watson for the Office of Darcel D. Clark, and the people respectfully request that this court affirm the judgment of the Bronx County Supreme Court. The motion court exercised sound discretion by summarily denying defendants' 440 motion. Contrary to defendants' contentions, it's clear that the 440 court was applying the 440-34A legal merits bar in denying defendants' claims. The court assumed that Moses' statements were true and analyzed them under the 440-10-1G factors. Defendant simply failed to establish a legal basis for his motion. First, Ms. Moses' affidavit was not newly discovered evidence. Defendant concedes that Ms. Moses' info, and Your Honors pointed out, was known to defense long before trial. In concluding this, the motion court relied on this court's decision in People v. Taylor, in which this court stated that information known to a defendant from early in the proceedings cannot be said to have been newly discovered. Shortly after the motion court denied defendant's motion, this court reaffirmed that holding in People v. Rosales, in which a fellow inmate's affidavit stating that a defendant was not the shooter was a look-alike named Yepes, was not newly discovered evidence because before trial, defendant received discovery indicating a man named Yepes was a suspect, and defendant knew Yepes. And two of Your Honors, Justice Manzanet Daniels and Justice Moulton, heard that case. The cases relied upon by this defendant are distinguishable. They do primarily deal with co-defendants who were exercising their Fifth Amendment right against self-incrimination, so the specific information in their account was not known before trial. But crucially, as the motion court concluded, the information in Ms. Moses' affidavit would not have probably changed the verdict. As Your Honors observed, the complainant's identification in this case was particularly strong. Mr. Archie was face-to-face with defendant. They could have shaken hands. He knew defendant quite well as his neighbor and a friend of his stepson. They had interacted multiple times over the months prior to the attack, and Mr. Archie, despite being an older man, had perfect vision. He only wore corrective lenses for reading. He recognized defendant immediately. He testified repeatedly that he was very sure it was defendant because he would not have let a stranger into that building. Mr. Archie identified defendant during and before the attack. The court characterized his testimony as strong, consistent, detailed, credible, and the evidence against defendant as overwhelming. And in contrast, Ms. Moses' account was vague and weak. As Your Honors observed, she was not an eyewitness. She did not see the attack. She did not give a specific time she arrived home that evening.
Counsel, this is Justice Moulton. Also, her affidavit does not describe the complainant's, what he looked like. It does describe the two men that she observed, but that was remarkable to me, and it seems to undermine the timing to a degree because she doesn't say that the complainant was bloody or looked like he was shaken up.
That's absolutely true, Your Honor. Your Honors, this was a very serious, violent assault. Mr. Archie was very, very seriously injured. He had multiple fractures to his face, his eye sockets, his nose, his jaw. He testified that he was left semi-conscious and covered in blood in the wake of this attack. And it beggars belief that someone could have arrived at the building in the wake of such a violent assault and not recalled any of those shocking details. Moreover, she didn't see Mr. Archie's face. She didn't notice any blood on the area, on Mr. Archie, or on the men. And crucially, as the court pointed out, it was incumbent on defense to set forth in the affidavit details that would establish the probability that if the jury heard from her, they would have rendered a more advantageous verdict. Defendant suggests that her testimony could be further fleshed out in a hearing, but if there were more details that Ms. Moses recalled, she was given essentially unlimited time to reflect and draft her affidavit. And those details could and should and must have been included in that affidavit for the court to consider.
Do any of my colleagues have any further questions? Thank you.
Thank you, Your Honors.
Appellant.
Thank you. In my remaining time, I'd like to address the sentence here because it is excessive. For Hashim Harley's entire life, everybody who has known him, including the complainant, knows him to be a sweet, shy, kind, respectful, family-oriented young man. He went to church. He took care of his niece and nephew. He helped his mom when her health issues started to get bad. He tried in school despite really serious cognitive difficulties. This enormous mitigation counters the sentence imposed here that is double the minimum term and will result in Mr. Harley having spent a full third of his young life in prison when he's released. He has no prior convictions, and he has significant cognitive deficiencies. This single act of violence is an aberration, and if this court doesn't see fit to reverse or vacate Mr. Harley's conviction for any of the reasons in the briefs, I would implore this court to reduce his sentence in the interest of justice so that he can begin putting his life back together.
Do any of my colleagues have any further questions? Thank you. Thank you both. Lembo versus Rosania. The appellant may proceed.
Thank you. Good morning, Your Honors. Jennifer McDougall for Appellant Robert Rosania. We're here today on the appeal of the denial of a motion to dismiss breach of contract claim, declaratory judgment, and unjust enrichment. My client, Robert Rosania, is a real estate investor and developer. In 2010, he was the CEO of a company called Stellar Management, which owns and operates commercial and residential real estate, primarily in New York. At this time, due to the financial crisis, many of Stellar's real estate deals were underwater, with the cash flow not meeting the required debt service. One such property in financial distress was Park Merced, which is located in San Francisco, California. In 2010, my client negotiated—
Counsel, we're familiar with the facts. Could we get to the issue at hand? Why should we ignore the emails that reflect the arrangement between the parties?
Sure, Your Honor. I acknowledge that in the lower court, the trial court did allow Mr. Lembo to submit certain emails that he claims show that an agreement was reached.
And this court has so held that that is an appropriate holding. So explain why those emails do not illustrate and show an agreement between the parties.
Sure. And I think in order to satisfy the statute of frauds, the email must set forth the parties to the agreement, the subject matter of the agreement, all the essential or material terms, and include the parties' electronic signature blocks. And we simply don't have that here. We have
Before we even get to that, why does the statute of frauds apply?
Well, because this is an agreement that involves an interest in real estate, Your Honor.
Isn't it a refinancing deal, not exactly the transfer of real estate? It's the refinancing of debt on real estate. That's not the same thing.
Well, Mr. Lembo at times claims that he is entitled to an interest in an LLC company, a limited liability company.
It's an equity interest, isn't it? It's an equity interest, not an interest in real property.
Yes, Your Honor, but there are a series of cases from this court where this court held that if a party had an oral agreement to have either shares or an equity interest in a limited liability company whose sole assets would be real property. That agreement was barred by the statute of frauds, and we cite that in our opening brief. A series of cases from this department, recent cases as late as 2011, where this court denied, affirmed the denial of a motion to dismiss or dismiss claims that were pled on this basis.
If this court gets past the statute of frauds issue, again, I ask you, how do you get past the emails that demonstrate an agreement between the parties?
Yes, and I don't think those emails do demonstrate an agreement, respectfully, Your Honor. This is a series of emails, some that Lembo wrote to himself, some are written by non-parties. They do contemplate some agreement, but they don't set out all of the material terms. And I think when you look at these emails and the allegations of the pleading in all together, what they show and what our client affirmed to is that there were discussions about potentially entering into an agreement about this property.
I'm sorry, didn't Gluck, who is after all the principal, correct? The non-party principal here?
He is, Your Honor.
Okay, and did he not say that the plaintiff here was a real, and I quote, was a real partner with all the rights and responsibilities of partnership, entitled to reciprocal rights and remedies, and he instructed his attorney to draft the parties' agreement accordingly?
Yes, Your Honor.
That sounds pretty clear to me.
Yes, Your Honor, but I'd point out two things. First, there's another email where Mr. Gluck himself also says, don't promise anything to my employees relating to Park Merced. And two, these emails show that there were attempts, there were drafts negotiated, drafts circulated of this agreement. The party, Lembo, commented on them. And these agreements were never executed, they were never signed, they were never made formal. There were a lot of discussions that took place, but there was no ultimate agreement where all the parties agreed to all the mutual terms.
Counsel, what material terms, you said there were material terms missing. What material terms were missing in the email?
Sure, Your Honor. So, if we're conceding that Lembo is saying that he was entitled to an equity interest in a limited liability company, what we don't have are all of the members of this company. We don't have any obligations to make capital contributions, which are, standard material terms that are set out in a limited liability company agreement. We don't have the time of performance, when Lembo should have received proceeds. And we don't have the duration. In fact, at various times, Lembo alleges in the complaint that he was entitled to funds in 2010, but then at other times he acknowledges that they were still negotiating some sort of agreement in 2012 and 2013. And it's unclear when he would have been, paid out under this agreement or for what term it would have proceeded.
Counsel, this is Justice Moulton. There was a course of conduct between these parties, of course, and I know that can cut both ways, that 9 other deals were paid and there were agreements with respect to those 9 other deals. However, it also created a course of conduct between these parties, so that it was almost routine. So on a motion to dismiss, hasn't he alleged sufficient facts to show that at least he should survive a motion to dismiss? Because other factors, there are ways of filling in a contract which are sort of factual. And so given the course of conduct that they've done this before, couldn't he argue that this is a routine thing we did, and we were, had agreed on this, we just hadn't filled in all the blanks? Isn't that sufficient for a motion to dismiss?
I don't think so, Your Honor, especially when you have this complete lack of and complete contradictory allegations of assent. You don't have our client here, fully signing off on this agreement. What you have is, these real estate, investors and developers sort of going back and forth saying, I hope I can do something for him here. His employer is saying, the head of this company is saying, oh, do something, but maybe not do something. And you just don't see an agreement here. And I do think it cuts in our favor the fact that these 9 other properties were fully documented, fully signed off off on. But you have a party here who, 6 years later, even though he knows he hasn't been receiving any funds from this property for this entire time period, then comes back later and says, oh, by the way, this property is now extremely successful. You promised me in an oral agreement and in a handful of emails that I'm entitled to $11 million of that from that property. So I just don't think the facts cut towards Mr. Lembo here.
I mean, your problem is it's a 30-11 motion. So it's whether as a matter of pleading you can prevail. Do any of my colleagues have any further questions? Okay, so let's hear from the respondent. You have time in response, of course. Respondent?
Good morning, Your Honors. May it please the court, Jeffrey Berkowitz for the respondent, plaintiff Matthew Lembo. Fundamentally, what seems to be getting lost here in appellant's arguments is what was the contract. The contract was not the documentation of the LLC. The contract was, Mr. Lembo, restructure this property in San Francisco for me, Park Merced, and if you succeed, and I, Robert Rosania, who owns a significant portion of it, don't lose my equity, I'm going to give you 2.5%. And if Larry Gluck's taken out of the process, that interest will increase to 5.83%. It's a very basic contract. And what happened and what's going on here is at some point,
basic contract, but there are a lot of terms missing.
Well, it's a very basic contract, and the terms, Your Honor, that were going to be documented were memorialized in 9 of 10 agreements. And what happened here is that Mr. Rosania left Stellar Management, set up his own company as alleged in the complaint, and he tried to, we'll use various hashtag symbols as opposed to words that wouldn't be appropriate in court, tried to abscond with what was essentially an $11 million interest to Mr. Lembo on the first refinancing. And at the end of the day, what keeps getting lost here, but Justice Scarpula recognized, was the contract was the basic performance of the restructuring. And what's going on here is Mr. Rosania drug his feet on documenting it in terms of the implementation. But the emails and the oral agreement, which all could be performable within the statute of frauds, clearly was the restructuring concept. And it certainly, as Justice Moulton pointed out, at the pleading stage, been satisfied. And what I keep running into when I read the briefs, when I appeared in the court below, is the goalposts keep moving. It's the basic terms of the complaint are there for a cause of action. This is a notice pleading situation. It's clear that Mr. Rosania has notice of what the claims are, that there was a contract to give Mr. Lembo, if he was successful, an interest in Park Merced. When that's satisfied, the goalpost moves. And there's this constant argument about, well, the mines weren't met, or there's a missing material term. And when you point out what's there, another term gets raised. One of the arguments they raised for the first time in the reply brief and hinted at in the moving papers was the notion that where were the shares coming from? There's an email in the record that says, and I'm quoting from Mr. Rosania, don't overemphasize any one issue, since clearly no one controls the promote being the dollars, except me. That will never change, since one person needs to control, but I'm not exactly shy to make money. And it's, I believe, on page 89 of the record. And I note that the record may not have been reproduced properly. As you'll see, if you look at Mr. Lembo's supplemental affidavit in paragraph 1, the emails were highlighted, and I think the electronic filing system converted the highlighting into what looks like redactions. And if Your Honors want me to send in a corrected set, let me know. It may be that the electronic copy reflects properly that's available to the court. But practically speaking, the contract was formed. This isn't a statute of frauds situation. It's a situation where the contract was performable within 1 year. It was an interest in real estate. So we get this. So recognize it, not an interest in real estate. It's a personal interest in a limited liability company. So what we get is, oh no, that's really an interest in real estate. But there were management companies as well that were involved in running this 3,000 plus apartment complex in San Francisco. That's also asserted in the complaint. And all of this could have been performed within 1 year. The restructuring could have been performed in 6 months or 3 years. The ownership interest could have been performed. Mr. Lembo could have sold immediately if he had wanted to. And this argument that the ownership would go on indefinitely, which is what Mr. Lembo believes, doesn't mean that it requires it to be a written contract. If you don't form an LLC agreement, you default to the statute.
Do any of my colleagues have any further questions? Thank you. Appellant?
Thank you, Your Honors.
Thank you. So I just want to turn back to one point we made in our brief, and something that my colleague pointed out. And he says that this contract was to restructure the property. To be clear, Mr. Lembo was an employee of Stellar Management. He was carrying out this work as an employee. There's no allegation in the contract that Mr. Lembo was carrying out this work for Mr. Rosania's personal profit. In fact, the complaint specifically alleges that Lembo believed that, quote, Rosania, as an officer of Stellar, would abide by an oral contract. And that's at page 33 of the record, paragraph 10.
Did you raise that argument below?
We did not raise this below, but we believe that this argument can be viewed based on the pleadings itself. And I'll note that in Justice Scarpula's decision, we actually made this argument based on a point that she raised in a footnote of her decision, pointing out the fact that Mr. Lembo had not made any allegations against Mr. Rosania outside of his capacity as an employee of Stellar. And there's no allegation that Rosania agreed to be personally liable to Lembo for any of his, Stellar work or for any compensation that he owed, or that Rosania personally agreed to act as a guarantor of any debts or contractual obligations allegedly owed to Lembo. So unless the panel has any further questions, I'll just thank you for your time.
Thank you. Thank you both.
You're welcome. Thank you.
Thank you.
Leffler versus Kotick. The appellant may proceed.
Thank you. Thank you for granting me oral argument. Mr. Leffler, using his superior knowledge in dentistry, hijacked the judicial system. He perpetrated a major fraud upon the court, asserting there was metal on 2 teeth, simply to exculpate his defendant client. I, using my superior knowledge in dentistry, although it had no impact personally, as the lower court mistakenly stated, I knew the judicial system was hijacked. I knew with 100% certainty Mr. Leffler had perpetrated this enormous fraud on the court. I found Mr. Leffler's conduct chilling and reprehensible. So I did, as the late John Lewis espoused, if you see something, say something. I reported Mr. Leffler. Mr. Leffler then, with ultimate chutzpah, again hijacked the judicial system, filing a frivolous lawsuit for defamation, an insult to the First Amendment, asking the court to direct me to pay him money damages. In response, I submitted a motion for summary judgment with legally sufficient affidavits. My own affidavit as an orthodontist that swore under oath with 100% certainty there was no metal on these teeth. I saw them personally as the client had his bridge in his hand, and I swore under oath. I have been reading x-rays for 60 years, and there is no metal on the x-ray in issue. I submitted the affidavit of Dr. Chesnut, the dentist that took the x-ray, who explained with 100% certainty there is no metal based on the x-ray, as well as seeing one of the teeth clinically.
Counsel,
I submitted
this is
sworn-
Justice Moulton. On page 4 of your brief, you say that the perjury had no impact on the case. So doesn't testimony have to be material in order to be perjury?
Not in a civil action. Doesn't have to be material to be perjury in a civil action.
What's your basis for saying that?
And I'm not suing him for perjury. I'm being sued for defamation. My whole defense is that everything I said is true.
True, right.
Whether I defined perjury or said he lied, it doesn't matter. He's not being tried for perjury. I don't understand the significance
Your
for the perjury.
Your statement was that he committed a crime, isn't that right?
No, my statement is he committed perjury. To me, perjury is a lie.
Okay.
Perjury may be to be found criminally responsible. You may be correct. It has to, but it has nothing to do with him suing me for defamation. I cannot defame somebody if I said something that is true. That is the First Amendment. And I produced affidavits that supported my position. Should I continue, or is that not clear?
You can continue, but your time is almost up.
I submitted 4 affidavits. Mr. Loeffler submitted no affidavits. He did not submit his own affidavit. He didn't submit the affidavit from the person I said had lied. He didn't submit an affidavit from the expert that lied. The lower court did not consider these affidavits, and I beg this court, simply read the affidavits. It's an insult to the First Amendment and justice. Mr. Loeffler should not be awarded money from me for his mischief. And one last statement. There is no bribery in this case. I never, under no circumstances, did I imply or accuse Mr. Loeffler of bribery. The word was created by Mr. Altman, his attorney, and repeated by the lower court.
Do any of my colleagues have any further questions? Thank you.
Thank you.
People versus Ford. The appellant may proceed.
Good morning, Your Honors. Anastasia Heger from the Office of the Appellate Defender for Ian Ford. Trial court in this case abused its discretion when it adjourned deliberations over defense objection from a Wednesday to a Monday in violation of 31010. And on this basis alone, the conviction should be reversed. The legislative materials for the amendments to CPL 31010 from last
Counsel.
Yes.
Let me interrupt you for a moment. The intended adjournment was just for one day, isn't that right?
Counsel initially consented to this, yes.
Right, and it had to span over the weekend because a juror called and said they were experiencing a slight fever and a sore throat, correct?
The judge did excuse the juror on that basis, yes.
So my concern here is that you would have us espouse a holding that if an emergency happens after a Thursday adjournment and something happens on a Friday that forces the court's hand to adjourn, that automatically equals a violation of this rule and would require either a mistrial or I'm not sure exactly where this leaves us. It opens the door. This could happen again. So is that the holding you want this court to come down with?
Your Honor, actually, I would disagree. I actually think this is a very narrow case. First of all, the legislature changed the law last year. But let's put that to the side. In the change of the law, the court was very clear, the legislature was very clear that the old law gave an inflexible outside boundary of 24 hours. They said, now this new law is going to, and they use the word, provide the discretion to extend beyond that. I think that they agree with you, that they wanted judges to have more flexibility. The narrow issue in this case is that they also put a definitive start date on the new law. They also said what it applied to. It does not include Mr. Ford's case. So the question here is that the judge did violate the law on the grounds that he believed that he had the discretion to do so. But we know now that the court didn't have the discretion to do so. So I think that's really what we need to be evaluating here. Under the new law, but even under the new law, a judge that wants to extend beyond 48 hours needs to make a finding of good cause. And I think another thing that you had mentioned about, an incapacitated juror, I think if we look at the facts of this case, that's not really what was going on here. If we look at the colloquy on that Friday morning, even the prosecutor is noting that it's more like the juror just doesn't want to come in and says to the...
I may not disagree with you, but was a record made about that? Was there an attempt to push the juror a little into getting them into court? Was all of this on the record?
Well, what we do have on the record is the prosecutor saying once, he says as to juror number 9, he says basically, we have no choice here. He's basically just told us he's not coming in today. And then tells the judge, when we call everybody back, the 11 jurors that showed up in bad weather, you really should use, he said, some force and say, you really need to be here on Monday. I would argue, Judge, and I know there are a lot of legal standards floating around here, but even under the new law, you have to have good cause. And I think that that's a demonstration. Everybody knew that there wasn't good cause. The prosecutor said, look, we're letting people have adjournments for things that in a perfect world we wouldn't countenance, like, that we have let this go on too long. The problem here, Your Honor, is that we need to look, what was the law that was in effect? The law said 24 hours. The court said in its oral decision and its written decision, I know I'm violating 31010. I just believe that I have the discretion to do so. And the bill jacket and this new law make clear that he didn't have the discretion to do so. So that's really the narrow issue before this court. I think that this is a very specific set of facts here, and I don't think this at all opens the door.
Counsel, before we run out of time, this is Judge Kern. Can you also address your other argument about that the court erred in finding the verdict to be non-unanimous without poll?
Of course, Your Honor. So on that Wednesday, the jury delivered what was obviously sort of a head-spinning decision. They were asked for their verdict on count 1. They gave a vote breakdown. Everybody realizes that's not a unanimous verdict, but then they go on to count 2, and they say...
They realize that because they see the verdict sheet, not because any information is imparted from the jurors that were not unanimous.
Actually, Your Honor, the first day, no one had looked at the verdict sheet. This was something that was announced in court. The judge said, I'm not taking your verdict right now. It has to be unanimous. And then a number of colloquies begin. On that Friday, the prosecutor says, I've talked to my appeals bureau. I actually think that this guilty verdict that they gave on count 2 is a necessary acquittal on count 1 under Fuller. There's some more discussion about it. Since they're not going to be holding court that day, they decide to look over the weekend. On Monday morning, the prosecutor makes this application again. Says, I think under Fuller, defense counsel says, I researched it too. But they agree that what they need to do is to poll the jury to find out if they did have a verdict on count 2. But here's where things went sideways. Instead, the judge says right beforehand, I want to look at the verdict sheet. Now, I will absolutely grant you that the notations on the verdict sheet raise alarms because it looks like the jury actually didn't get it. However, we miss the step of actually asking them. There's tons of case law saying that notations on verdict sheets don't mean anything. They don't have any meaning in the law. The problem was to skip and just assume that that was the problem and then send it back to the jurors. Yes, the court did give an instruction on unanimity, But the problem here is if you don't really explain or initially ascertain whether or not there actually was a defective verdict, I mean, potentially.
Counsel, this is Judge Kern. Your position is that the error that occurred was the failure to poll the jury and instead rely on the verdict sheet. And that's where it went sideways.
Exactly, Your Honor. And I mean, if they had in fact had a verdict on count 2, and then it gets sent back without an actual explanation of why it's being sent back as to count 2, since they just said guilty on that before, that could lead them to think, was that the wrong verdict? Is there a reason? Is there, and like I said, if they actually did have a verdict on one, then we violated double jeopardy and sent man 1 back to him. Ultimately, Your Honor.
Thank you. Are there any further questions? Let's hear from the respondent. The appellant has further time on reply.
Good morning, Your Honors. ADA Nicole Nichols for the Office of Darcel D. Clark. Initially, Your Honor, the recent amendment to CPL 310.10.2 is applicable to this case and completely disposes of defendant's claim. The legislature amended that amendment to now give courts discretion to adjourn matters for 48 hours without cause and 72 hours with cause.
Was counsel incorrect that the new statute has an effective date that postdates the trial?
It does, Your Honor. But traditionally, cases on appeal are decided by the law that exists at the time the appeal is being heard.
Does that ever happen when the statute specifically states a effective date?
But
I mean, that happens when it's silent, but when there is an effective date in the statute, can we ignore it and apply it retroactively?
Your Honor, I believe in this instance, the court also, in deciding the scope of the statute, the court also has to look at the intent of the legislature. And when this very statute was previously amended in 2001 to give the courts the discretion to adjourn cases, this court held that that statute was procedural and that it applied to cases pending on appeal. Here, all the legislature did was expand that time limit. It moved it from the 24 hours to 48, and we assert that it made explicit that which was understood before, that the courts had discretion to grant adjournments for matters of emergency. Therefore, given that that prior statute was procedural, the legislature knew that this court had previously held that that statute was procedural and applied to cases pending on appeal. It's reasonable to infer that that same application was intended here. And there's really no reason to not apply this case to cases pending, this amendment to cases pending on appeal, given that the courts have already said that this statute does not implicate any substantive rights of the defendant. That
Counsel, can you address the other issue? Sorry, Judge Friedman.
I was going to ask for the same thing.
Okay. The unanimous verdict, the record shows that the verdict was not unanimous. First, this issue is not preserved because defense counsel did not object to this before the trial court. In fact, defense counsel agreed there was no unanimous verdict and that the matter should be resubmitted, that both counts should be resubmitted to the jury. But here, this case, we have various indices of reliability that we can rely on that the verdict was not unanimous. Initially, the foreperson stated when the verdict was announced Wednesday, without any prompting, he stated that the verdict on the man 1 was 7-5. And then once the court said we do not want that, he stated guilty as to count 2. Now, on Monday, after the judge explained on Wednesday that the verdict had to be unanimous, it again explained that on Monday before submitting the counts that it required the verdicts to be unanimous.
Yeah, so this is Judge Kern. I understand you're talking about indicia of reliability, but why specifically was it not error for the court to fail to poll the jury once there was some ambiguity about whether or not it was unanimous? Why wouldn't that be the appropriate way of determining whether it was or was not in fact unanimous?
I believe here, Your Honor, initially the intent was to poll the jury. But once they saw the verdict sheet, which confirmed what the foreperson had announced the prior Wednesday in terms of the 7 to 5, and now it showed 5 to 7 for the second degree, there's here all the parties agree that taking that, the foreperson's comment plus the verdict sheet showed that it wasn't anonymous. And defense counsel, again, the court had initially said it was going to pull the jury.
Counsel, what about the case law, though, cited by opposing counsel that you can't rely on a verdict sheet?
Again, I said here there are other indications that take this case outside of just the verdict sheet, given the foreperson statement. And in addition, after the case was submitted, the jury promptly submitted a note saying we are unable to reach a unanimous verdict. So it showed that there was some confusion with the jury where they thought that, a majority vote was okay. But once the error was explained to them, they promptly came back to the court and said, we can't reach a unanimous verdict. So I think here we certainly have evidence beyond just the notation on the verdict sheet.
Does the defendant have a problem in raising this issue with preservation?
Yes, Your Honor. She said this issue was not preserved. A request to correct an illegality in a verdict must be preserved for appellate review. And defendant did not preserve it. Not only defendant not preserve it, we argue that he waived it by affirmatively asking the court to resubmit both counts to the jury.
Do any of my colleagues have any further questions? Thank you. The appellant.
Your Honors, I'm sorry, but respondent is entirely incorrect about the retroactivity. Not only is there an effective date in this law, it says, quote, shall apply to all criminal actions pending on or after such effective date. Criminal actions is a term of art in the criminal procedure law, and they terminate upon the imposition of sentence, something specifically that this court has recognized.
Let me turn your attention to the preservation issue. Why doesn't the defendant have a problem with lack of preservation when you raise this verdict issue?
On to the second issue. Yeah, I mean, Your Honor, we did have a preservation issue. We are asking this court to either deem this a mode of proceedings error or to consider it in the interest of justice. Because when you look at these errors in the totality, you really look at everything that happened in these jury deliberations. I think my adversary just mentioned, well, look at them sending a deadlock note at the, shortly after being given the case back on Monday. I don't think it's just that they weren't reaching a consensus. They may have been confused. They may have been confused about why demand 2 wasn't appropriate. It hadn't been explained to them. When you look at these things in the aggregate, in a case like this, it's so alarming. This was a case based on looking at intent. It was a very, very close self-defense case. In fact, when the prosecutor was arguing for an analysis under Fuller on Monday, the judge said to him, so you think there's no remote or possible reason that the jury would reach a unanimous verdict on count 1? The prosecutor says, yeah, I get that sense, but not just from this jury, but the history of this case, there was a prior jury. This was such a close case that these errors, the 3-10-10 error, the sending it back without explanation error, this is not a verdict that we can have confidence in. And for those reasons, we would ask this court to reverse.
Any further questions? Thank you. Thank you both.
Thank you, Your Honor.
Val versus the Port Authority. Appellant Port Authority may proceed.
Good morning, Your Honor. May it please the court, Jonathan Schaub for the appellant's respondents, the Port Authority, and Turner Construction. The dispositive issue on this case is whether plaintiff was the sole proximate cause of the accident. The record irrefutably establishes that he was. To set the stage, plaintiff was the general foreman for Donaldson Construction, and as the general foreman, he was the highest ranking.
He was the foreman for the cement boards, correct?
Correct. He was the
foreman. Clear. Okay.
He was the general foreman for Donaldson, which meant he was Donaldson's highest ranking employee on the job site at the time of the accident. He was also OSHA's competent person, and as the competent person, that meant that he had the training to identify safety issues.
Counsel, I'm sorry to interrupt you. This is Justice Moulton. I know you point to a number of decision points where the plaintiff might have made another decision that might have forestalled the accident. But overlying all of this, or a larger problem, is the allegation that Turner stopped allowing the use of a hoist to take materials down to level B4. And that necessitated the use of the truck, which led to all these various decisions that resulted in the injury to the plaintiff. So, I mean, doesn't that create an issue of tribal fact at the very least concerning sole proximate cause?
Well, Your Honor, that's an excellent point. First, the Supreme Court entered summary judgment against Turner and Port Authority on the 240. So that in and of itself was a mistake, because there is a tribal issue of fact as to whether the hoist was available. So on that basis alone, the decision should be reversed.
So there's a clear discrepancy in the evidence about whether or not this had been barred from happening anymore, using the hoist.
Correct. There was an affidavit put in by Turner at page 1861 of the record that establishes that the hoist was available, or there's evidence that the hoist was available, and that it was plaintiff's decision.
Does the affidavit state and refute that the construction manager at Tower 2 advised the plaintiffs that trucks would no longer be unloaded at street level and that deliveries would henceforth be made by truck delivery to the B4 level? Is there anything in the record that contradicts that statement specifically?
Page 1861 of the record, where the affidavit from Turner's representative says that the lift was available on that day. But I think that this brings forth.
My question is not that. My question is whether he was directed to have all direct deliveries from henceforth delivered by truck. It's not whether there was a hoist on site. This was a World Trade Center site. Of course, there were hoists. No, the question is whether he was directed not to utilize it.
Your Honor, the testimony is, or the affidavit says, that the hoist was available for use. So that contradicts the notion that there was no hoist available and he was directed not to use it. But
okay, we're talking at each other, because I'm not saying there was no hoist. My question is very specific.
And it was,
and I'm not hearing you contradict what I'm saying. Was he directed to do deliveries by truck from henceforth?
The testimony is that the hoist was available and that it was his decision not to use it. That contradicts that is a contradiction in the evidence that it was unavailable and he was instructed not to use it. But I think the larger point here is that there is no obligation to provide every single conceivable safety device. There was, in fact, an adequate safety device in this case, and plaintiff used it to unload the majority of the boards.
Let's discuss this issue of sole proximate cause. As I understand this record, because the truck had to go through a winding, as described by Scachetti, your own witness, that it goes through a winding process through several towers in order to go down 4 levels to the sub-base, the most extreme, lowest level of this site. And the record shows that part of this process was that roadway was rocky and bumpy, and often your own witness said they had to walk down the roadway in order to get rid of debris in the way of the trucks, and that they had to do that on this day, and that the truck did indeed go over a construction plate that shifted the load.
Your Honor,
so is that not a fact that would prevent and absolutely prohibit a finding that the plaintiff was the sole proximate cause?
Your Honor, well, plaintiff walked that route the morning of the accident, and he had the absolute authority to terminate the delivery if he was concerned or felt that there was an issue with the safety. He didn't terminate the delivery. Second, he was in the truck when it struck that plate. And when it struck the plate, he got out, saw that the load had shifted, and he alone, in his discretion and authority, decided to continue with the delivery. There's no dispute that he had the authority to terminate the delivery and send it back to City Lumber for packaging. And
isn't there a dispute that he alone decided how to resolve the problem that resulted from trying to take this load down? Didn't he consult with his crew and they all agreed on the method of unloading this truck together? Isn't that what the record
he was
says?
he was the ultimate supervisor and the general foreman, so it was his absolute authority and discretion. He doesn't dispute that it was his decision. And then so there's two decision points.
So does our case law say that if a worker makes a bad judgment call in his work, that have we changed the 240 sub 1 case law that says that comparative fault is not applicable on 240 sub 1? Because it sounds to me like that's what you're talking about.
Well, Your Honor, I think there's two cases. One was a case that you were on the panel for, and it's Kerrigan versus TDX Construction. And in that case, it was the supervisor didn't actually rig the load that resulted in his demise. He supervised it, as did the plaintiff in this case. And he made every critical decision that led up to the accident. And this court found that he was the sole proximate cause for that basis. And then there's also the decision in Guido versus Dormitory Authority, which is a case Justice Friedman was on, where the plaintiff appreciated the risk, continued to proceed despite the risk, and when he was injured, this court found that he was the sole proximate cause. So to break this down, the plaintiff defined the task at hand. It was his decision as to how to unload it. He selected the means and methods in this case. It was his decision, and I can't emphasize this enough.
Am I wrong that he was able to, in the manner that he chose to unload this truck, am I wrong that he was able to successfully unload 6 loads prior to this one falling on him?
He was able to unload.
Obviously, the method was not so bad. He was able to get almost the entire truck unloaded.
Correct. He was able to do it. And then he made the decision to transfer the mode of removing the boards.
No, the record says that he was able to remove by pallet jack 6 loads before this one fell on him.
Your Honor,
they started by removing 25 to 30 cement boards by hand. Correct. And then the crew decided to use the pallet jack, and they used it on 6 pallets before this one fell on him.
I think that's where the discrepancy requires a point of clarification in the record. There was the load that had not shifted. That was easily removed with the pallet jack. There was then A-frame carts that were used to remove approximately 30 cement boards. At that point, plaintiff, as the person in charge, indisputably the person in charge.
Counsel, according to the record, the cement boards were first removed by hand, and then the pallet jack was utilized.
The pallet jack was used to first remove the load that had not shifted, because there were 2 stacks. There were 2 pallet jacks. One pallet jack did not shift. The pallet jack, or I'm sorry, one of the loads did not shift. The pallet jack was used to remove that one. Then they turned their attention to the load that had shifted. And on the one that had shifted, they used those A-frame carts to take off 30. Plaintiff then, as the general supervisor and indisputably the person in charge of the crew, decided to use the pallet jack. He then also decided to stand next to the load, placing himself in harm's way. And then he devised and designed—
Doesn't the record say that he stood there in order to try to replace the broken pallet?
Correct, but he chose to use—
So there was a purpose for him standing there, not just negligence. Let me stand somewhere where something might fall on me.
Well, yes, but it was negligence because he didn't continue using the A-frame cart to remove the cement boards. That decision caused the accident. His sole authority, not exercising his sole authority to send the load back for repackaging, which there's no dispute he had the authority to do.
Was the shifting of the load his fault too?
He was the one who designed. He was the one who instructed City Lumber on how to package the load for it to be delivered. And again,
but he didn't package it, right?
Correct. But if we look at Kerrigan,
and it did not work.
Correct. But if we look at Kerrigan does not require that the plaintiff undertake every single action. It's sufficient if the plaintiff is supervising or setting up the scheme, as they did in Kerrigan, as this court decided.
You're way past your time.
Thank you, Your Honor.
So let's hear from City Lumber.
Thank you, Your Honor. Glenn Kaminsky with the firm Amity Demers McManus, counsel for the respondent appellant City Lumber, and we would respectfully ask this court to reverse the decision as it pertains to City Lumber. Let's assume here that a sole proximate cause is somehow not dispositive of this case. The claims against City Lumber should still be dismissed. After acknowledging that City Lumber was not a labor law defendant, the court below found an issue of fact as to whether or not the packing and strapping properly secured the load. In this case, let's assume arguendo.
Wasn't there also an issue raised about your truck driver driving too quickly and that action caused the shifting of the load? Isn't that part of the reason why factually they were held in?
I don't believe that's exactly how the court below worded it, Your Honor, but for the purposes of this appeal, I'll adopt your position that somehow created an issue of fact as to the negligence of City Lumber. But at worst, all of this, the packing, the driving, only furnished the condition or occasion for the accident. It was not an actual cause of the action. This is not a case where we were driving, the load shifted and instantly crushed someone, a pedestrian or the plaintiff. This is something that the load shifted, they got out, no imminent danger. They looked at it, they parked the truck. Plaintiff, again, with all the decision-making ability, looked at it again and decided how to unload the vehicle. He could have turned it around. He could have had it repacked. He decided that the vehicle
turned
would be
around
unloaded.
the truck where?
That he could have said, he said he had the authority to refuse the load.
This roadway, based on the description in the record, is a narrow, winding, bumpy road.
I don't disagree with you, but the truck did leave the site eventually. So
but it has to get down to a level where it can do that, not on the winding road, correct?
No, but again, they got all the way to the loading dock and the plaintiff was not injured. The load was still on the truck and he decided at that point in time, I'm going to unload, we're going to have this load unloaded.
But
and
by the time it reached the
a
bottom level, counsel, wasn't there a part of the load that was hanging?
There was a part of the load that was hanging.
So that traveling up that same winding road with a hanging load was safer than trying to unload it where it had to go?
It may well have been but what we do know is that the plaintiff was not injured when the load was at the loading dock until he directed it to be unloaded, that he directed not only to after he got the first undamaged load, if you will, the first pick, and then he gets the 30 boards off on the second pick using the A-frames, and then decides that I'm no longer going to use the A-frames, which he could have continued to do without incident. And he goes to the pallet jack. These are superseding intervening causes that
counsel,
sever the
Justice Moulton. I mean, obviously there can be more than one proximate cause of an accident. It isn't what Judge Mazinet just said possible that at this point they had to go down to the basement. They had to do something with the load, and so that wouldn't have happened had the truck driver had the packing been better done. I mean, for argument's sake, and if the driving hadn't been so rapid. So that could be, a jury could find that that's a dual proximate cause, an additional proximate causes of this accident, and not just the circumstance that gave the occasion for the accident. So, I mean, isn't that a jury question?
I don't believe so, because the acts of the unloading and changing how they were unloading it, from doing it by hand when you got to the damaged dunnage pile, the picks with the damaged dunnage, those acts were independent and removed from City Lumber's actions. The load is sitting there. It's not falling on anyone until such time as the plaintiff decides to change how he's unloading it, to change it to the pallet jack. So whether you call it sole proximate cause, which we certainly agree with, but in any event, it's a superseding intervening cause. We only furnished the occasion for this accident. We weren't the cause of it.
But you would agree that it's at a minimum a jury question.
And not as to City Lumber. No, I would disagree with you, Your Honor, respectfully, that the facts as they sit right now, in viewing them in a light most favorable to the plaintiff himself, still would not create a jury question as to City Lumber. And unless this court has any other questions.
And you certainly contended you belong out in the contractual indemnification because you didn't have a contract to indemnify.
Of course, you know, I didn't want to burden the court with.
It's okay. I just wanted to check.
Yes, I will say this: no claim for contractual or common law indemnity can actually be brought against us. Certainly, contractual, there's no contract. Common law, there's certainly.
Thank you. Any further questions from my colleagues? Mr. Singh, you may proceed.
Thank you, Your Honor. Whether or not that Alamac hoist was usable or in operation is, as Justice Manzanet pointed out, absolutely and totally irrelevant. Turner, in its wisdom, decided there would be only one access to this job site, and that was the roadway that led to the B4 level. So if you had to go to the B4 level, the Alamac hoist is doing you absolutely no good whatsoever. What they didn't provide was a truck-mounted hoist or a gantry crane or something of that nature that could have allowed this to be unloaded in a safe manner. As far as so clearly the equipment that was needed to do this in a safe manner was not provided.
But counsel, can you respond to appellant's argument that in fact they had dealt with the broken pick of boards and they had mostly used A-frame dollies, and then it was the decision of Mr. Valle to go back to using the mechanical means for removing it, and that's what caused the accident. So in other words, there were the A-frame dollies were the safety equipment that was sufficient for the job.
Yeah, I mean, I think that the legislature, in its wisdom and in enacting 240, has always said that we realize that workers are constrained by the circumstances of their work. They're constrained by the orders and the directives of the general contractor and owners. That's why we're going to recognize the realities of what the construction is like. And the reality.
So A-frame dollies good enough or not? That's my question.
No, we're forgetting the key fact. They were given a 2-hour window between 5 a.m. and 7 a.m. to unload all these cement boards. They can't unload everyone individually, by hand at that time. And we don't even know that that was a safer method of unloading it. They were constrained by time. They were constrained by by the reality of getting these concrete cement boards off the truck. And there was no way on earth they could have done that if they were taking everyone out individually. And now also there was no conceivable way, assuming that he was in some way negligent in his supervision or his choice of methodology. The fact remains he didn't load the truck. He didn't drive the truck. He didn't restrict the unloading to a 2-hour window early in the morning. He didn't require that the truck. The only method of accessing the work site was through this circuitous and bumpy and poorly maintained road.
But counsel, did he have the autonomy to abort the job? Could he have just said, "Let's get out of here. This isn't safe"?
He could not have done that in at the same time fulfilling his duties to do what he had to do to unload that truck with the constraints that were placed upon him. No, he didn't have an option. He could not have turned back the truck. First of all, it was physically impossible. Second of all, he made clear that was probably the safest thing he could have done, because if he had gotten the truck down to
why was it physically impossible to turn the truck back? I mean, obviously the truck is coming out of there.
It's a narrow road, and it's a very constrained road, and there was construction on all sides of that.
Well, how does it get out after the unloading is finished?
Well, I think once it got to the dock area, it could be turned around. But then again, he's in the position is, what am I supposed to do? Send back this truck with the load, the cement boards leaning over the side of the truck. How is the driver going to get out of there? They had to be unloaded at that point. He didn't have an option.
Did he say that in his EBT, or where's that in the record, that there was no option but for unloading once they got to level B4?
I believe he said it. I can't give you a specific site.
Do you think you cited in your brief? Because I don't remember seeing it, but I'll look for it.
I don't recall, but it was certainly in my mind that was the circumstance. But in any event, it's a matter of logic. I mean, what is he supposed to do with this truck with the overhanging load? It had to be unloaded at that point. So there's no conceivable way that he was the sole proximate cause of the accident. So there's no reason to have a trial, because a comparative negligence on the part of the worker is not a defense to a labor law section 240 action. So and if there's no way that he could be the only proximate cause of the accident, then there's nothing to try. What you have is a clear prima facie case that this load was not safe, that the appropriate devices were not provided, and a violation of the statute was established. So at that point, the comparative negligence is not a defense. And as the motion court correctly determined, the sole proximate cause defense is inapplicable. This court cited similar cases that are barely mentioned or addressed in the defendant's briefs. One is the Grant case that Judge Friedman is familiar with. There's also the Ali case, a very similar factual case that you, Judge Moulton, were on. These were factually similar cases. The load, as it was being hoisted, fell on the worker. That's a 240 liability. And since it's inconceivable that he was the sole proximate cause of the own accident, he was properly awarded summary judgment on his labor law section 240 claim.
Any further questions? Thank you. Court Authority, Appellant, 2 minutes.
Thank you, Your Honor. I want to just address a couple points that were made. First, there is absolutely no obligation under the labor law to provide every single conceivable device like a gantry, a forklift, or any other type of instrument. As Justice Moulton properly pointed out, he did have a safe way of removing the cement boards from the truck. It was the A-frame, the A-frames. He chose not to do that. He consciously made a decision, and that was the cause of his accident. So we focus on the packaging and the driving. That's not the 240 violation in this case. There would not have been an accident if plaintiff had not decided to attempt to unload those boards. That was his decision.
You heard plaintiff's counsel say that there wasn't time to continue to use the A-frame dollies. Can you respond to that?
Yes.
No,
so
they had to get out of there because we know that the roadway was going to be used for other purposes. That's why they were delivering this stuff starting at 5 in the morning.
Well, first of all, they would.
Okay.
They would not have needed to use the A-frame, or they would have not needed to use the A-frames for the entire load. In fact, they used the pallet jack to remove one of the loads successfully. And we know they'd removed 30 boards by hand. And as the record shows, there were approximately 60 boards in a pick. So all they needed to do was remove 30 more boards. It was his decision then to change this methodology to this incident. And then there's the affidavit from the Turner representative that says under no circumstances would we have told him that the truck had to be out by 7 a.m. if there was a safety issue. And this is not, as my colleague suggests, a case where workers can't be distinct employers. He was the boss. He was the highest ranking employee on the job site for Donaldson on that day. Now, just to give a couple record sites to clarify several things, on record page 604, it says that plaintiff had the authority to return the load. And on 622 of the record, it says plaintiff concedes it was his decision and his decision alone to unload the boards using the A-frames. So on that basis, if we consider Kerrigan, he decided how this was going to happen. He chose the means and methods, and it was his decision that led exactly to this accident.
And any other questions? Thank you. Thank you all.
Thank you.
Petrishko versus Animal Medical Center.
Yes, Your Honor. Good morning. This is Ian Wallace for Petrishko, the appellant. The appellant worked for the Animal Medical Center from July 2015 until her forced departure in January of 2017. She was the director of marketing for the animal hospital. She was subjected to various reprisals that were triggered by an opposition she made, various oppositions to an unlawful wage deduction by policy by the employer. Initially, initially initially in February of 2016, when the defendants...
Counsel, we know about these allegations. Would you address the statute of limitations issue? And why doesn't the complaint anchor the statements allegedly made to particular dates and times?
Yes, Your Honor. Because of the multiple and the repeated nature of the defamatory statements, it was impossible to anchor it beyond what was alleged in the during the period late December 2016 until March 2016. Sorry, late December 2016 until March 16, 2017, Ms. Vogel and other employees of AMC, especially those who worked in close vicinity to the CEO's office, heard defendants Coyne defame Ms. Patricia on a daily basis, many times per day, by repeatedly calling her diabolical, evil, unstable, and pathological liar and a narcissist, and of being a drug dealer and addicted to drugs. So this case is very different, on a different footing to those cases cited by the court and also the AMC that cited cases that found that the allegations were too lacked specificity according to date and according to the actual defamatory statements themselves. Here, the defamatory statements have been worded, specifically worded, and this is continuing on a daily basis. Ms. Vogel, who was the key witness here, I guess the lower court was looking for particular days of particular statements. That was impossible here because of the continual and repeated nature of these attacks. So the administrative assistant would have been required to have kept a tape recorder running. She worked next to the CEO, or would have been required to have kept a diary of the exact times and days that these statements were stated by the CEO. An impossibility. It was not feasible. So during this period,
why was that not feasible?
I
mean, literally, all it does is require you to make a notation on a piece of paper, and to preserve that piece of paper. That is not an onerous requirement, and doesn't our case law state very clearly that this is one of the requirements for this claim? You must state when and where.
And it is, we have stated that in the complaint, Your Honor. The where is stated. Right
yes,
next
but
to
not the when. The exact dates were not stated, and our case law requires that.
Granted, Your Honor, the case law does on occasion require it when it's one or two or three comments. However, here, this case is on a very different footing because this is continual.
That's the rule. If it's more than 3 comments, it's not required?
It's very, it would depend on the facts of the case, Your Honor, but here, because this is repeated on a daily basis, the administrative assistant is right next to the CEO's office with the door open, and this was a continual.
Which case stands for that proposition, counsel, that the requirement to give a specific date is relaxed if the allegation is of repetitive, ongoing statements?
There is no case that applies that specific fact pattern, Your Honor. What is very distinguishable are the cases that do require the exact day in question. Usually involve, and all those cited in this case, usually involve 2 or 3 comments at best. Here it would be unfeasible, completely unfeasible. The administrative assistant, Ms. Vogel, who's the key witness, isn't the plaintiff here. So she had no motivation to sort of record these daily continuous comments.
Any other questions by my colleagues? Counselor, thank you.
Thank you.
Let's hear from the respondent.
Thank you, Your Honor. My name is Lou DiLorenzo. I represent the individual defendant here, Catherine Coyne, as well as the Animal Medical Center. I won't spend a lot of time on the defamation claim. We've explained in our brief, I believe very thoroughly, that the statements are either time barred, non-actionable statements of opinion, or they lack the pleading requirements that some of the questions have already elicited. And you've heard the claim that it was impossible to allege it any more specifically. I would just like to give some context to this case. We got an original complaint, and prior to responding to that complaint with this 3211 motion to dismiss, the plaintiff amended as of right, adding some additional allegations. We then served our motion to dismiss, explaining all these problems with the defamation claim, the tortious interference claim, as well as the retaliation claim. He responded to our motion with a proposed amendment improperly, but the court below actually said we'll accept the amended complaint in an effort to see if any of the defects that exist with all three claims could be cured, and they specifically found that they couldn't. In fact, with respect to the tortious interference claim, there were basically three claims for contractual breach. One was the at-will employment at the Animal Medical Center. The other one was the potential job interview situation with Compassion First. And the third one was the Beacon Hills stables. The allegation that was added when we asked for specificity on time, place, and manner with respect to defamation, because the tortious interference claim that he's brought, or she has brought, is based upon a claim of defamation. There needs to be a tort with respect to inducing the breach of the contract. The tort here was defamation. The amended complaint on page 157, the second proposed amended complaint, paragraph 132, ends up with an allegation based on certain information with respect, for example, to Beacon Hill. And the claim is that, therefore, upon information and belief, defendant Coyne must have made a statement to somebody at the stables to get her kicked out. The same defect exists with respect to the Compassion First job. She claims she had an interview. She was told she was going to get a firm offer subject to employment references. And then afterwards, she was told that, quote, according to 137 on page 158 of the record, Compassion First was not in a position to move forward with her hiring. At oral argument, Mr. Wallace described that as she was told they decided to move in a different direction. There's no proof whatsoever whether there was any reference check, who gave any information, if there was, what the information was, and certainly it cannot be assumed in a defamation or tortious interference case relying upon defamation as the tort that Ms. Coyne made that statement. With respect to the retaliation claim, as we've argued in our brief, there's no adverse action here. This is all of these things, for example, the questions about why there wasn't recording or notations made, it's because she enjoyed the job there. She got angry one day, decided to quit. A few days later, asked that her resignation be rescinded. That was denied. She worked for another 6 weeks, according to her, in intolerable conditions. She didn't bring a lawsuit to a year later. And I submit that that lawsuit was brought in retribution for not accepting the resignation. That's why there's no allegation of any ability to record alleged defamation statements or otherwise. They've been given three chances to cure these pleading defects. I think that's enough. Some of the changes in position on the appeal would be a fourth, and I think that would be improper. Unless anyone has any other questions or any questions, I'm going to sit down. Thank you very much, Your Honors.
Thank you. Thank you both. Green versus State of New York. Appellant may proceed.
Reserve 1 minute for rebuttal.
You didn't reserve.
Okay, Your Honor. Cy Green spent almost 23 years in prison for murdering.
I'm sorry. You want to save a minute for rebuttal?
Yes, may I, Your Honor?
Of course.
Thank you, Your Honor. Cy Green spent almost 23 years in jail for a murder he didn't commit. Newly discovered evidence post his release from prison shows not only that he is innocent, but also that law enforcement intentionally secreted evidence from him. In fact, not even all the evidence has been produced today. The singular thesis of the state on this appeal is that the claimant, appellant, is absolutely bound by a 2006 order that was fraudulently induced by prosecutors withholding evidence. We now know since 2006 what evidence was withheld, and we can show now that that evidence fully corroborates 3 confessions of the actual assailants. In 2005, Judge Michael Pesci ruled...
Counsel, can I interrupt you? What about the Section 1983 case, the way it ended? I mean, in that case, it was, was there a false arrest? Was there misconduct? It wasn't obviously about his guilt or innocence, but it was about what the police did. And so summary judgment was granted in that case.
Yes, Your Honor. A disappointing result, but this court and the Court of Claims is not bound by that result. That's not collateral estoppel. It's not res judicata. And Judge Donnelly just simply didn't address all the elements of misconduct that were in our papers. And in fact, there was a problem in that case that doesn't exist here. My predecessor, the attorney Myron Beldock, failed to name 2 of the prosecutors who withheld the evidence in a timely fashion. Therefore, the claim against those prosecutors could not be pursued against the city. In other words, we were left with a more difficult theory of liability. So she didn't address individual prosecutors' liability with the same circumspection that you will in this court.
But she did find that there was no Brady or Rosario material withheld, which mirrors what Judge Pesci found in 2006.
Judge Pesci didn't have the evidence we claim that now exists.
Okay,
In
but
fact,
you got
Your
2
Honor,
judges saying it at 2 different occasions. So in 2017, Judge Donnelly did say that in her decision.
Yes, and Judge Donnelly, I submit to you, was incorrect. She did it without an evidentiary hearing, which we requested. I mean, if you look at the evidence we put in on this record, undeniably there were Brady violations, and there were intentional secretions. And Judge Pesci in 2005 said, if you can corroborate the confessions, I will basically find Mr. Green innocent. The problem was significant evidence was still being withheld, including the fact that the lead detective, Michael Nerito, interviewed the 2 principal assailants who were seen escaping in a cab. He didn't complete a police report. He didn't file any notes. He never identified these individuals. But today he said in 2009, he testified post-conviction release that they were Panamanian. That fully corroborates the confessions of 3 of the people that are described in our papers.
Thank you. Respondent?
Good morning, Your Honors. Linda Fang on behalf of the state. The narrow issue before this court is whether or not the Court of Claims properly dismissed the complaint. There is no dispute between the parties that claimant's conviction was vacated in 2006 solely on the basis of ineffective assistance of counsel. And that is not an eligible basis for advancing this claim under the wrongful conviction statute. The statutory language is very clear that in order to present such a claim, claimant needs to provide documentary evidence that his conviction, quote, was vacated on one of the grounds that the legislature deemed as eligible for recovery. And he cannot do that on this record. And his arguments about whether the conviction should have been vacated on other grounds really are not properly before this court here. And then just to talk about this,
where can he raise those arguments if below he asserted other grounds for the vacating, and the court decides to limit their decision to one ground and decides not to opine on the other issues, but they were raised? Is that not fair, unfair? To then prevent counsel from seeking recourse under Section 8B?
And Your Honor, just a couple of responses. He was not prevented from seeking recourse to address these issues. The Brady and Rosario allegations were made before Judge Pesci and were denied by Judge Pesci and were fully considered by Judge Donnelly, not only in a 70-page summary judgment opinion, but also by a unanimous panel of the Second Circuit Court of Appeals. So multiple judges have passed on this. And again, 8B is a unique statutory scheme. It was created by the legislature as a supplemental remedy. And as this record shows, the individual here, Mr. Green, had ample opportunity through 7 years of extensive discovery, 30 depositions, including the district attorney for Kings County, in an extensive federal proceeding that was resolved in a summary judgment finding that was affirmed by the Second Circuit. So he's had ample opportunity to raise these issues. And here we don't even have an instance where the Judge Pesci was not reaching these other issues. He rejected those issues. So 8B does not give him, claimant here, an opportunity to relitigate for the 4th, 5th, 6th time these issues that he's had full opportunity to litigate. And so unless the court has further questions, we ask you to affirm the dismissal and apply the statute.
Thank you.
Thank you, Your Honors.
Your Honors, I ask you to look at one thing before you push us under the door. Page 302 of the record, a map diagram of the eyewitness statements showing the path of the brown-shirted stabber. And then I will submit to you that the end result of these men being chased, they went to this cab. The audio tape of that interview was buried and has still not been produced by the district attorney's office. The transcript of that interview has never been produced to Mr. Green or the court. A fraud has been perpetrated by the court, upon the court, by the district attorney's office. This interview transcript, which undeniably exists, it was viewed by attorney Myron Beldock in 2004, requested in 2005, has never been produced. Why is that so significant? This cab driver said the 3 men who entered his cab spoke Spanish. Mr. Green does not speak Spanish. He also said the man with the brown shirt was 5'10". Mr. Green is 5'1". There was an NYPD informant in this cab. The NYPD did not want to release any information regarding the informant or what he was doing on that day. Justice, please, Your Honors, please look at page 302 of the record and consider the confessions of the actual assailants. Mr. Green has never been given a fair day in court. Not in a civil rights case where Judge Donnelly said, I'm not interested in his innocence. Literally in the record, she said that. And you will not see the misconduct unless you look at his innocence. He's absolutely innocent of this murder, and he's never been exonerated from it. And
Thank you.
Criminal defense attorney was blamed, and that's absolutely wrong.
Thank you. Thank you both. This concludes oral arguments for today. Court is adjourned.